Welcome to our April 2023 edition of This Month in Payroll. I'm Claire Soccio, a partner in PwC's Payroll Advisory and Operations practice. April has seen a number of developments that have a significant impact for payroll, and in this edition, we're going to concentrate on three: a federal court decision that sets a new precedent for public holiday rostering, the introduction of superannuation guarantee into the national employment standards, and an update about the proposed criminalisation of wage theft. We'll begin with looking at a significant decision of the full bench of the federal court that has potential implications for all employers rostering workers on public holidays. Until now, it's been common practice for employers to impose public holiday rosters on employees, and an assumption is often made that generous public holiday rates mean employees are willing to accept those rostered shifts. This decision, which relates to a subsidiary of BHP, has really challenged that historical practice. The court has concluded that employers cannot mandate employees to work on public holidays without first seeking the employee's agreement. And that's the case even where a contract of employment, award, or enterprise agreement suggests an employee may be required to work on certain public holidays. The case involved BHP's Operations Services, an internal labour hire division of BHP, which had rostered 85 employees to work on Christmas Day and Boxing Day in 2019 at a central Queensland mine. The mine operated 24/7, and the relevant contracts of employment included a clause that employees may be required to work on public holidays. BHP rostered those 85 employees to work standard 12.5-hour shifts on the two public holidays in question. And relevantly, the employees didn't receive extra pay for working on those public holidays. The Construction, Forestry, Maritime, Mining and Energy Union, known as CFMMEU, successfully argued that requiring these employees to work on a public holiday contravened one of the National Employment Standards and the Fair Work Act, which provide that employees are not required to work on a public holiday. Rather, the Fair Work Act allows an employer to request that an employee work on a public holiday, and the employee is allowed to refuse the request if it is not reasonable or if their refusal is reasonable. In this case, the federal court ultimately concluded that BHP's Operations Services had breached the Fair Work Act by mandating the employees to work on a public holiday. The court described the inherent power imbalance that exists between employers and employees, and that this power imbalance may result in employees feeling compelled to accept rostered shifts, and to not understand that they have the capacity to refuse a request that is unreasonable. In reaching its conclusion, the court considered in detail what a request of an employee should constitute, and it observed that in this case, the employer did not consult with the employees as to whether they were willing to work the public holidays, and did not tell staff they had the right under the Fair Work Act to decline to work. So what are the key takeaways for employers? Even where a contract of employment or an industrial instrument provides for employees to work on public holidays, employers cannot assume or require employees to work on those days. Simply rostering staff onto a public holiday without seeking agreement is not enough. There needs to be a level of discussion or negotiation, and the workers need to understand that they are being asked and not required to work. If you engage workers on public holidays, you should revisit the language contained in current contracts of employment or enterprise agreements relating to the rostering of work on public holidays. And in light of that language, consider the processes in place to seek agreement from employees to work on public holidays. You need to be comfortable that any request made of an employee is reasonable, that active steps are taken to confirm the employee's acceptance of the requested shift, and that the employee is informed of their genuine right to refuse the proposed rostered shift if their refusal is reasonable. Another significant development was the introduction of the Fair Work Legislation Amendment, Protecting Work Entitlements Bill 2023, which proposes a number of changes to the Fair Work Act that will impact payroll. These include expanding the circumstances in which employees can authorise deductions from payroll entitlements, where those deductions are not for the benefit of the employer, strengthening employees' entitlement to flexible unpaid parental leave, and the change we will focus on today, which is inserting an entitlement to superannuation contributions in the National Employment Standards, or NES, of the Fair Work Act. NES are minimum employment entitlements that have to be provided to the vast majority of employees in Australia. Workplace instruments, including awards, enterprise agreements, and employment contracts, cannot provide for conditions less than the NES. There are currently 11 minimum NES entitlements, which include annual leave, long service leave, notice of termination, and redundancy pay. The superannuation guarantee regime has until now been administered by the ATO, and non-compliance is currently regulated by the Commissioner of Taxation. The change to include superannuation in the NES will give employees the right to pursue unpaid superannuation as a workplace entitlement, including through the Fair Work Ombudsman or their union. This is a significant change, as individuals don't currently have a legal standing to directly pursue the underpayment of superannuation unless an entitlement is specifically included in their employment contract. Rather, any claim for unpaid super has to be made by first approaching the ATO. Another key implication is that breaches of the NES entitlement to superannuation contributions will be subject to the compensation and penalty regime in the Fair Work Act. This means that orders for compensation and civil penalties can be applied for a contravention. So who will ultimately regulate superannuation compliance? The proposed dual regulator approach is unusual and raises questions about how the Fair Work Ombudsman and the ATO will work together and operationalise this change. The bill doesn't provide a clear view about how employee claims or employer voluntary disclosures will be managed where super underpayments are identified in the future. We expect that both the Ombudsman and the ATO will need to provide guidance in due course about questions such as the appropriate channel through which employee complaints or employer self-disclosures should be made in the first instance, and how the two regulators will interact in relation to investigative and compliance activity. If a NES claim is successfully pursued and a court order provides for a superannuation payment, whether the employer will still be required to lodge superannuation guarantee charge statements with the ATO. The intersection of penalty regimes available to both regulators, including civil penalties under the Fair Work Act and the 200% Part 7 penalty from the Superannuation Guarantee Administration Act, and the required length of remediation in voluntary disclosure contexts, noting that the Fair Work Act and the Superannuation Guarantee Administration Act provide for different claim and record-keeping periods. What should employers do now to prepare for this change? Employers need to acknowledge and address the continued regulatory focus on superannuation compliance. The inclusion of superannuation in the NES reinforces the government's view that the underpayment of superannuation is a form of wage theft and worker exploitation. We also know that the ATO is relying heavily on real-time single-touch payroll Phase 2 data to understand employers' superannuation compliance and to target their regulator compliance activity. This is yet another reminder for employers to get on the front foot and stress test their own compliance with super obligations, including looking at the language in awards, enterprise agreements, and employment contracts to understand the obligations, and to identify any unintended differences that might be created between the different instruments, examining existing structures and processes relating to superannuation, and testing payroll system mapping and STP Phase 2 labelling. And now to our final topic for this month. In mid-April, the Department of Employment and Workplace Relations released consultation papers for the second tranche of industrial relations reforms, which are intended to be introduced in the latter half of the calendar year. Amongst the range of consultations underway is one focused on the criminalisation of wage theft and reform of civil penalties in the Fair Work Act. Proposed reforms, including options for a criminal offence and increased maximum penalties, respond to two recommendations made in 2019 by the Migrant Workers Task Force. These changes are intended to strengthen the compliance and enforcement framework of the Fair Work Act and to increase the penalties and enforcement tools to a level that deters wage underpayments and drives cultural change amongst employers. You may have already seen the headlines: jail time for directors, HR and payroll managers, and employers facing $4 million fines. So let's look at some of the key reforms that are being explored. The department is considering options to criminalise wage underpayments, which may include the imposition of fines and/or a period of imprisonment where employers knowingly or recklessly underpay employees, or a tiered approach which contemplates both scenarios. Recognising that underpayments are often enabled or concealed by a failure to keep accurate time and attendance and payroll records, it also proposes to criminalise record-keeping misconduct. The objective is to treat record-keeping misconduct as seriously as the underpayment itself, and goes well beyond the reach of the existing civil remedy provisions of the Fair Work Act, which already require employers to make, keep, and give accurate records. The paper briefly contemplates the appropriateness of offence-specific defences, such as a due diligence defence for reckless underpayments. It questions whether an employer should be able to defend itself where it can evidence that reasonable steps were taken to mitigate the substantial risk of an underpayment. Examples of those steps might include the establishment of strong payroll governance and a program of proactive payroll compliance monitoring. The department reflects that the current civil penalties are not deterring employers from non-compliance with civil obligations, and therefore proposes options, including to increase maximum civil penalties fivefold. This would mean that for individuals, the new maximum penalty could be $82,500 or $825,000 for a serious contravention. And for companies, the new maximum penalty could be $412,500 or $4.125 million for a serious contravention. Penalties for both criminal and civil convictions are proposed to be imposed at a level that both punishes the offenders and also deters others from underpaying workers. And to reinforce the deterrent element, the department also explores whether the courts should be empowered to order penalties at the higher of the maximum penalty units, like we just discussed, or up to 3 times the amount of the underpayment, where that underpayment is able to be quantified. The intent of this option is to enable the order of a higher penalty in situations where the amount of the underpayment itself is much larger than the maximum available penalty. These proposed reforms could shift the dial enormously for employers, as well as directors and key personnel involved in the accurate delivery of payroll. Feedback submissions are due by 12th of May 2023, and reforms are expected to be introduced in the second half of the year. Noting the impact for our audience, we will monitor these developments closely and provide you with updates as the final legislation takes shape. And on that note, that's it for this month in payroll. If you would like to revisit any of our prior updates, they're available on our website at pwc.com.au/payroll. And if you have any questions or need for support, please reach out to me or your usual PwC contact. Until next time, have a great month in payroll.